Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. You know, one of the great pleasures about getting to run Washington Gun Law is getting to talk to all of you lawful and responsible gun owners all around the United States. And I am amazed by the number of you who have already decided to go ahead and just jump into the Amnesty registration pool right now with your firearms with attached stabilizing braces. In fact, I have fielded many calls with questions about people wanting to know about the specifics because, as they put it, they want to get out in front of things. Well, as you know, we're picky here at Washington Gun Law about never telling you guys or gals how to think, but at least giving you all the stuff that you should think about. And that's exactly what we want you to do today, because maybe some of you might decide to tap the brake pad just for a little bit. So today, let's spend a few minutes and explain why I'm not doing any Amnesty registration right now. Okay, so the issue we're talking about today is pistol brace E-Form 1 Amnesty registration during this 120-day period now that the ATF's new rule on firearms with attached stabilizing braces have published. Now, just to go back and make sure that we're all on the same time frame here, the rule published January 31st of this year. We have 120 days from date of publication for the rule to be in full effect, which means the rule will be in full effect for all of us by May 31st of this year. Now, for FFLs nationwide, this rule has already gone into effect, and there's all extra hoops for you to jump through. Many of you have decided, hey, you know what? I'm just going to get out in front of the wave. I'm going to beat everyone to the punch, and I'm going to go ahead and get my firearms registered right now through an E-Form 1 and take advantage of this tax-free registration period. Now, let us remember that ATF has specifically stated that so long as we have an approved application within that 120-day window, so whether that approval happened on February 4th or it happens on May 27th or May 29th or May 30th, so long as we have an approved Form 1 submission, we are allowed to lawfully possess our firearm pending approval or denial of that Form 1 application. Now, to many of you that I've had the pleasure of speaking with on the phone, what I've told you, and you will know this, and the rest of you are going to learn this right now, is I'm not doing anything with any of the firearms that I think fall under the purview of this new rule for at least 30 to 45 days. And the reason is I do believe that the legal landscape, as we look at things 30 to 45 days from the date of the publication of the rule, sometime in early March, may be significantly different than it is today. Let us not forget that there is not one, not two, but at the current time, 3 separate lawsuits that are meant to stop implementation of this rule. And we've done videos on all 3 of them. The first lawsuit, the first one to jump into this soiree, was the Firearms Policy Coalition filing a lawsuit in the Northern District of Texas in a case called Mock v. Garland. Now, that has many very well-founded arguments in that lawsuit, including that it violates the Second Amendment's common use test. And as we know, there is a rich historical tradition of the federal government being allowed to regulate firearms which are both dangerous and unusual. However, by the ATF's own estimate, there is somewhere between 30 to 40 million of these firearms with attached stabilizing braces. Certainly does not make them particularly unusual, therefore not subject to federal regulation. And then there are additional lawsuits in there, all based upon the Administrative Procedures Act, and we actually did a lot of geeking out about the Administrative Procedure Act, but the rulemaking itself was arbitrary and capricious, that it's void for vagueness, and the fact that the agency is acting in an ultra-virus fashion outside the clear delineations of the separation of power, not like we've ever had that complaint about the ATF. That lawsuit, of course, is asking for a temporary injunction. Let's remember that, okay? Then along comes the second lawsuit, and we did this video on it right there, and that is Brito versus ATF. Now, that also is filed in the Northern District of Texas, this one in the Amarillo Division. And I loved the pleadings in this case because not only did it go through, again, the same Second Amendment analysis of the common use test as what the Firearms Policy Coalition had done in Mock v. Garland, but it also deeply dove into the separation of powers, the ongoing violation, the violation in perpetuity that is the ATF of the separation of powers, but most importantly, and bravo to plaintiffs' counsels here, pounded away at the West Virginia versus EPA case, a case that came out about a week after the Bruen case. And we have done this video and this video here because we believe that the West Virginia EPA case is the case that truly boxes in the ATF. Then in addition to all of those arguments, they also went through all of the Administrative Procedure Act void for vagueness. They're clarifying a statute that doesn't need any clarification. If they do believe the statute is vague, therefore the rule of lenity would apply, and therefore we would still rule in the defendant's favor. It's a very well-crafted set of pleadings. That case, again, is Brito versus ATF, and they too are asking for a temporary injunction. Remember that, okay? Okay, and then along comes the third lawsuit. We did this video on it right here. Now, that suit is Firearms Responsibility Accountability Coalition v. Garland. That is filed in the United States District Court in North Dakota. Now, in addition to a couple of named plaintiffs such as SB Tactical, what makes this lawsuit so unique and what has us so excited about this lawsuit is that it has 26 states named as plaintiffs through their attorneys general. And so kudos to West Virginia Attorney General Patrick Morrisey, who managed to wrangle up 25 other states who have all joined as named plaintiffs against the federal government. And that lawsuit is also asking for a temporary injunction. Let's remember that. Now, these are the lawsuits that we have become privy to, have been able to read the pleadings all since January 31st. And we know that there are many, many more to come. But as I mentioned when we talked about all three of these lawsuits, we mentioned that all three of them were asking for temporary injunctions. What is a temporary injunction? A temporary injunction is a big fat pause button where the court basically says, you know what? Time out. This law cannot be enforced. Government cannot enforce this law until we resolve this case on the merits. And here's why temporary injunctions are really important, because what a lot of people think is the benefit is, oh, hey, we end up not having this law enforced on us in the here and now. And that is very important. But in order to prevail on a motion for a temporary injunction, if you're suing the government to try to stop implementation of the law, you have two-part test that you must prove in order for the court to even consider issuing the injunction. Number one, you must show irreparable harm. That is, you are going to be harmed in some fashion, and there is no way to make you whole if that harm occurs. And when we're talking about locking people up, putting them in prison, labeling them as felons, confiscating property, that is, in fact, irreparable harm, okay? The second part to the test, and this is the part I want you to focus on, is the plaintiffs must also demonstrate that they are likely to prevail on the merits of the argument, which means that the court, taking a look at all of the merits of the arguments on both the plaintiffs and the defendant's side, and analyzing the case law, analyzing the facts and the evidence of the case, they believe, you know what, there's a good chance the plaintiffs are going to win this thing. Then the temporary injunction is granted. So when you consider all of that, that is why we have decided that we're going to wait 30 to 45 days before we do anything. Obviously, the legal landscape could look significantly different next month if some of these temporary injunctions start being granted. And if we start seeing a chain reaction of injunction after injunction after injunction all being granted in different corners of the country, well, then the tea leaves begin to tell us that the end may soon be near for this pistol brace rule. Most importantly, and this is the most important thing to take away from this, we are not trying to tell you how to think about this rule, but we are trying to give you all of the things to think about. Listen, I'm sure you're going to have more questions about amnesty registration or anything else that's related to our Second Amendment rights. And if you do, remember, you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.